Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case with huge implications if you travel internationally into or out of Canada. This is the case of the King and Pike, and it deals with cell phone privacy as well as privacy for other digital devices like laptops and tablets and all sorts of things. So let's dive right in here. And this case also illustrates people say, why do defense lawyers defend people like bad people? This case provides a bit of an explanation for that, and I'll talk about that as we go. All right, so the case starts off with a bit of an explanation about what it's about and why it's important, so let's cover that. It says, and I'll just note, this is 118 pages. We're not going to cover all of it, but I will link the case in the description below so that you can check out the whole thing if you're interested. So this one starts out with millions of Canadians travel internationally each year with their personal computers, tablets, and smartphones. The contents of these devices attract some of the strongest privacy interests known to law because they're a window into their users' lifestyles, beliefs, interests, desires, relationships, finances, health, and much more. But one of Canada's border laws, namely Section 99(1)A of the Customs Act, authorizes border officers to search those devices without any reasonable basis. Two travelers, Jeremy Pike and David Scott, whose devices were searched under this law and who were consequentially charged with possessing and importing bad pictures, challenged the constitutionality of the law. Sorry for the euphemisms, but YouTube gets picky about things, and yeah. The principal issue in these appeals is whether Section 99(1)A of the Customs Act is constitutional. The answer is clear. It is not. Section 8 of our Charter of Rights and Freedoms guarantees everyone the right to be secure against unreasonable searches. I agree with the trial judge that Section 99(1)A of the Customs Act offends this basic guarantee because it authorizes border officers to search some of the most private information imaginable on the lowest possible standard to justify a search, namely, that in the border officers' own minds, they were sincerely trying to find evidence of border law violations. We'll talk about what they mean by that, but this is basically the standard the government was suggesting was appropriate. While sincerity is a good start, it is just not enough. Our charter requires more because Canada's border control interests temper, but do not eliminate or gut its protections. A reasonable search in this context requires a reasonable suspicion, meaning objective facts that establish a reasonable possibility that officers will find evidence of border law violations on the device. The Crown in this matter has not justified the law's failure to require those objective facts prior to conducting the searches, while the Customs Act requires for other highly intrusive searches, and which the Canadian Border Service Agency admits would not jeopardize its mandate. So let's talk about standards for searches, right? If the police want to search your stuff, what kind of standard do they need? And there's various standards that are sort of known to Canadian law. One of them, which is a fairly low standard, is just reasonable suspicion. And that is essentially a reasonable possibility that's grounded in some actual facts that are not just made up, that there's a crime going on. So what does reasonable suspicion look like? A classic example was in drunk driving law before they changed it, saying that if they could smell alcohol on your breath, that they might have a reasonable suspicion that you were an impaired driver. Now, note, it's not illegal to have a drink and drive in most circumstances, but it is illegal to be intoxicated past the point where it's affecting your ability to drive, and also the situation of if you've got too much alcohol in your blood. Just the smell of alcohol on your breath was not enough to get you to, oh yeah, that's probably a crime here. But it does get you to, it's possibly a crime here. So reasonable suspicion is a fairly low standard, but they didn't even require that for searching phones and laptops and so forth. All they required was good faith. And good faith basically just means that the officer is not doing it to screw with you. They're not doing it for an ulterior purpose. They're not doing it based on, racism or something else. It's such an incredibly low standard. It's basically just, are you trying to find stuff? And as we'll see, they used this enough that they were finding nothing more often than they were finding something. And we'll talk about why that's significant as well. Now, you might be saying, wait a minute, these guys had bad pictures, which is a very serious thing, and it sucks that they're getting away with it. Well, that's not actually what the case says. And this is a difference between Canadian law and American law, because they note, however, the unconstitutionality of this law does not entitle Mr. Pike and Mr. Scott to acquittals on the serious crimes against children with which they were charged. So, in Canada, the standard is a little bit different than in the US. In the US, once a sort of rights violation is found, the evidence is excluded. In Canada, there's a second step, which is to say, okay, they got this evidence by violating your rights. Would this actually bring the administration of justice into disrepute? And so they conduct a further analysis to say, okay, this evidence was obtained in violation of rights. Does that mean it should be excluded from consideration? And in this case, they determined their rights were violated, but the evidence still goes in, and they get convicted. And it's really hard to have sympathy for these particular individuals because bad pictures, and yeah. Oh well. So let's keep going here. However, the trial judge incorrectly excluded the evidence found on the devices because he failed to properly consider the border officer's good faith reliance on the existing law when conducting the searches. Mr. Pike's reduced expectation of privacy in his devices at the border, the moderate length of the delay in providing right to counsel, and the interests of society in trying these serious charges on their merits. The trial judge's decision to exclude the bad pictures found on Mr. Pike's devices and acquit him cannot stand. I would thus allow the Crown's appeal against Mr. Pike's acquittal, admit the evidence of bad pictures found on his devices, and order a new trial on the bad pictures charges. So he's going to have a new trial, and given that that evidence is going in, conviction seems likely. It's going to be hard for him to argue that he didn't possess the bad pictures if they're allowed to tender the evidence of the bad pictures. All right. So they also found that a 23-month house arrest sentence that was imposed on Mr. Scott was too light. And so they said, we would normally impose a 3-year sentence, but we're not doing it here because he'd already served most of his sentence and it wouldn't be fair, essentially. So, continuing on, they say, but Section 99(1)(a) of the Act, whose constitutionality is at issue in this case, and to which I refer to in this decision as the law, does not require officers to meet an objective threshold before searching the contents of digital devices. This law provides, in relevant part, that an officer may, at any time up to the time of release, examine any goods that have been imported. In other words, it authorizes agency officers, without forming any reasonable suspicion that a border law has been violated, to search any goods that people bring across the border with them or otherwise import, until officers authorize those goods released from customs for use in Canada. The agency relies on this law to search digital devices. In the past, until the Court of Appeal for Alberta decided Canfield in October of 2020, most courts which had considered the question had treated the law as being constitutional. So, there has been a real shift, and that shift is really recognizing how important our digital devices are in our lives, because there is just so much potential information and potentially damaging information on it. All right, let's skip ahead here. We're not going to go through the details of this. One thing I will mention is that Mr. Pike had been a teacher until he was convicted of bad acts against children and lost his teaching license. And part of the reason why they searched his stuff was because he admitted that he'd gone overseas to teach young children and then was returning back to Canada. And they're like, how about that? So, yeah. So the court finds the law violates travelers' right against unreasonable searches. Mr. Pike and Mr. Scott claim, and the trial judge ruled, that the agency violated their Section 8 charter right to be secure against unreasonable search and seizure. I agree. Like other travelers, Mr. Pike and Mr. Scott reasonably expect privacy in regard to their digital devices. The state's invasion of that strong privacy interest was authorized by a law, but that law unreasonably offends Section 8 of the Charter. It does not strike a fair balance between the privacy interests of travelers and the state's interests because it attaches the lowest possible threshold to one of the most intrusive searches imaginable. Now, to a certain extent, this case isn't about these people. This case is about everyone else, because we might not have a whole lot of sympathy for Mr. Pike and Mr. Scott. I don't particularly here. But I also, when I travel, don't want them imaging my computers for a couple of reasons. One, none of their business. But also, just the fact that there's a bunch of stuff on my phones and so forth that is private, especially as a lawyer. There's a bunch of stuff that may be privileged that I just can't share with a police officer because it might be, for instance, messages from clients or prospective clients. And that is a big, big problem. Okay, so carrying on here, we're just going to look at some of the critical issues. As I said, we're skipping over a lot of this because otherwise we'd be at this for hours, and we don't want to be at this for hours. So travelers reasonably expect privacy in their digital devices. They note, travelers have a direct interest and subjective expectation of privacy in the contents of their digital devices, which are the subject matter of the examination by the state agents. So a subjective expectation of privacy is, what do you personally feel about it? But there's also a requirement for that expectation to be objectively reasonable. For instance, if I think that there's a subjective expectation of privacy with regards to the outside of my house, the court would say, no, that's not reasonable because anybody walking down the street can see the front of my house, right? So I might have that subjective expectation, but it's not actually reasonable in the circumstances, but it is a requirement that you have that. So the court continues, that expectation of privacy is objectively reasonable because digital devices are a repository for an almost limitless universe of information, including sensitive and confidential information concerning travelers' lifestyle and personal choices. So when you think about the kinds of information that might be on a digital device and that might be revealed by such a search, it's incredible. You know, it might be your finances, like how much money you've got in your bank accounts might be there, or how little. It might be issues of who you're talking to, somebody who is engaged in infidelity. They shouldn't be, not cool, but the government doesn't necessarily need to know that just because you're crossing a border, and that information might be found on a cell phone. All of these things. People sometimes take pictures of themselves, and that might be because they're going to share those with, you know, a very good friend, or it might be, you know, sometimes people take pictures of themselves because they're like, hey, what's this blemish? So all of these are potentially, you know, people could have messages with their doctors or about their doctors. You know, it might be that you've got a cancer diagnosis that you just haven't told anyone. All of these things. So they note the law authorizes unreasonable searches. So they say the Crown is correct that the law authorizes the searches, but this law is unreasonable. It adopts the lowest possible threshold, namely subjective good faith purpose, rather than the reasonable suspicion threshold that the Charter requires. I next explain which searches the law authorizes, why the law's subjective good faith purpose threshold is unreasonable, and why reasonable suspicion is the correct threshold. So they note the law authorizes low threshold digital device searches. So the law at issue authorizes border officers to search any goods that travelers bring across the border with them until officers authorize those goods released from customs for use in Canada. The Crown argues that the law authorizes digital device searches because the electronic files those devices contain are goods. So an intervener said, these aren't goods. And the court said, I agree with the Crown. So, why are they finding these files to be goods? Well, they note Parliament made clear that it intended this broad meaning by defining goods to include not just some documents in certain forms, but any document in any form. So, goods includes any document in any form, and so that would seem to include, your text messages and so forth. They note the definition of document in the French version of the Customs Act confirms that electronic documents are goods. So this is actually an interesting point about Canadian law. Canada is a bilingual country, and so a lot of laws, but every law is written, I'm not sure if there's exceptions, but written in both English and French. And so the courts can look to the other language to interpret them. They can interpret them using the English and the French. And so they note, per the French version, a document is anything that records data that can be read or understood by a person, a computer system, or another device. This unambiguous definition expressly includes electronic documents, resolves any potential ambiguity in the English version, and confirms that the common meaning of document includes electronic documents. Okay, that reasoning makes sense to me. I'm convinced documents are part of goods. All right. That doesn't necessarily mean that they get to search them, though, as we'll see. So they say the law sets a low threshold. Because the law authorizes searches of digital devices, we must determine what limits, if any, it imposes on that search power. The Crown, the government, argues that the law guards against broad invasions of privacy by implicitly requiring the search to be proportional in its scope to a valid border law enforcement purpose, and that it is to be conducted manually. This argument fails. While the law does require border officers to act in good faith and pursue a valid border law purpose, it does not require searches to be proportional to that purpose or to be conducted manually. Now, the government here was relying on a border officer's policy that they sort of require proportional searches and that they do it manually, but their policy is not law. And so they were trying to pretend that the policy was law, but they could change that policy tomorrow, right? No problems. So border officers must use the law's search power in good faith and for a valid border law enforcement purpose. The case law recognizes this implied requirement, which the law shares with other search powers. But they're going to note that these limits are very minimal. They say this bars officers from indiscriminately scouring the devices and examining programs or files for no legitimate border-related reason. Border officers also cannot make search decisions motivated or influenced by racial profiling, nor can they use the law as a mere ruse or pretext to investigate non-Customs Act crimes. So they can't investigate crimes that have nothing to do with, like, smuggling or whatever. They can't use it to determine, like, did you, I don't know, did you cheat on your taxes or something like that? And what would a non-legitimate border-related reason be? Well, possibly something like, hey, this woman crossing is really attractive. I wonder if she's got nudes. In case Trooper Proctor decides to work at the CBSA. Yeah, that would be obviously wrong, right? Clearly wrong. They say that is as far as the good faith purpose requirement goes. It cannot be stretched beyond its modest rule of law preserving role of ensuring that border officers act in good faith and consistent with the Customs Act purpose to impose a proportionality rule or other prohibitions on more intrusive searches. To the contrary, as the trial judge found, the good faith purpose requirement permits wide-ranging inspections of digital files if necessary, because the information officers seek can sometimes be found almost anywhere in the device. And it's true. I mean, you can hide files in whatever random places you feel inclined. There's all sorts of techniques people might use to hide them and so forth. So, all right, carrying on here. They say the Crown's argument that the law prevents forensic searches and only authorizes manual searches also fails. This argument wrongly assumes that the law incorporates the agency's practice of only conducting manual searches under it, but nothing in the law's text incorporates this restriction. The agency's practice of conducting manual searches does not transform this restriction into a binding legal rule, and we cannot rewrite the law by reading it in. So maybe they could have made this law constitutional if they'd actually put that requirement in there, but they didn't do that, so we can't fix it for them. So the law's low search threshold is unreasonable. They say laws authorizing privacy intrusions are reasonable if they strike a proper balance between people's privacy interests and the state's interests. Courts assess search laws' reasonableness by considering 1. Their intrusiveness, 2. Reliability, 3. Oversight mechanisms, 4. Purpose, and 5. Criminal or regulatory nature. What does that mean? Well, typically they allow more searches for regulatory issues than they do for criminal ones, because our interests in not being sort of harassed by the criminal system are higher. Because typically regulatory stuff has, well, I was going to say less severe punishment. That is not necessarily true, but okay. So Simmons, a critical case in this area, grouped border searches into 3 categories. These are in ascending order of intrusiveness. 1, routine questioning, right? So it can be a search just to be asked a question. What's in your bag is a search. So routine questioning, searching luggage and belongings, and frisk or pat down searches. All of this is the lowest level of intrusiveness. 2, strip searches. Now, strip searches have a whole whack of rules that, apply to them, but strip searches. And 3, body cavity searches. So body cavity searches are understandably the highest level of intrusiveness, and you can imagine why they might want to do that at the border, because sometimes people smuggle things in places that the sun is not inclined to shine. So Simmons and subsequent cases also attach thresholds to these categories by applying the principle that more intrusive searches require greater protection and thus higher thresholds, right? The more, the more they want to get in your business, possibly right up in your business in the case of the body cavity searches, the more they have to justify it, right? So the lowest and only purely subjective standard, good faith purpose, applies to category 1, routine questioning and luggage, frisk and pat down searches. Because this standard does not impose an objective threshold, officers can perform these searches on all travelers if they do so for a legitimate border-related reason, and neither make search decisions motivated or influenced by racial profiling, nor use these searches as a mere ruse or pretext to investigate non-Customs Act crimes. So when you cross the border, you pretty much always get asked questions, right? So that questioning is a very much ubiquitous thing, and they're allowed to do that. They're allowed to question every traveler if they want. So, and theoretically, they can do frisk searches and pat down searches and look through your bags and so forth, but they can't take your pants off. So, as Mr. Scott and the CLA submit, these searches merit reduced protection not because the agency regularly conducts them, but because their subject matter engages reduced privacy expectations. Them digging through your bag, they might find some embarrassing things, maybe you got some marital aids or something like that, but it's not going to be quite as invasive as if somebody's able to go through all of your text messages with everybody ever, right? So next, Simmons required that officers meet an intermediate standard, reasonable suspicion, before conducting strip searches. Unlike good faith purpose, reasonable suspicion must be based on objective facts that show a reasonable possibility of a border law violation. So, reasonable possibility, not probability, not certainty, just a possibility. Could happen. So, but, it's got to be more than just the possibility that anybody could be committing a crime. It's got to be, there's something that specifically points to the possibility that this person is committing a crime. So finally, Simmons held that body cavity searches require an even greater but unspecified degree of protection. I would suggest that these searches require at least reasonable and probable grounds, because that is the next threshold after reasonable suspicion in ascending order of protectiveness. Reasonable and probable grounds also require objective facts, but unlike reasonable suspicion, those facts must show a reasonable probability of crime rather than a mere possibility. So if they want to get right up in there, they've got to show that you're likely committing a crime. Okay, so they note the law is unreasonable because I agree with the trial judge that the law is unreasonable because its purely subjective good faith purpose test undervalues travelers' privacy interests in the contents of their digital devices. That low threshold, coupled with the law's unreliability and lack of oversight mechanisms, authorizes the agency to invade the privacy of numerous innocent travelers who have little recourse to challenge its actions. So they note the Supreme Court has held that people have unique and heightened privacy interests in personal computer data because it can expose deeply revealing information. In fact, it is hard to imagine a more intrusive search because as our constant companions, digital devices record immense quantities of information concerning our friendships, love and sexual desires, finances, medical information, interests, and political and social views, as well as our future plans. They contain a digital record of nearly every aspect of our lives and could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, televisions, maps, or newspapers. Not only that, but they generate information without users' knowledge, retain data that users try to destroy, and let users access information stored on remote servers. So, as an example, every time you do just about anything with your phone, it records it as an event. So if you take your phone and you turn it like this, that gets recorded as an event. You know, your phone has noted that you have moved it, and it will record that. Sometimes people have been convicted on the basis of their phone moved or didn't move during a critical time. Accessing information stored on remote servers, like your banking information, is probably not stored on your phone, like how much is in your account and so forth. But you can quite possibly get to it through your phone, especially if they're requiring you to turn over passwords and so forth. So, in addition to these strong informational privacy interests, digital device searches engage travelers' personal privacy with respect to their bodies. This form of privacy is not limited to physical touching, but includes visual access to the body, such as by viewing photos or videos of the naked or undressed body. As a result, digital device searches risk engaging personal privacy because people often store intimate images on their devices. So the court has recognized that people sometimes take selfies of themselves with no pants. They say, I cannot overlook this risk because it has already materialized in a reported case in which border officers encountered and, albeit without improper intent, scrolled through intimate images while searching a device for contraband. So it's already been the case that they've found, you know, pictures like racy pictures. So this risk heightens the law's intrusiveness because viewing these images invades basic human dignity, even where agency officers scroll through them casually and without improper intent. All right. So, you know, because it could end up showing you naked, that's a big deal. The Crown's related counterargument that travelers' choice, and they put that in scare quotes, to travel with digital devices merits a lower threshold also fails. So the Crown's argument here is, you chose to travel with your phone, so now we get to look through it because you chose to bring this along. And the court's like, no. Now keep in mind, the judge probably travels, and the judge probably has a cell phone. So the judge also kind of has some skin in the game here, right? So because digital devices are our constant companions, quoting from a Supreme Court decision, travelers need to bring them across borders to work and communicate. Just as Canadians are not required to become digital recluses to preserve their privacy, they should also not have to surrender the ability to enter and leave Canada with an indispensable instrument of modern life. And the court notes that the reliability of these searches has not been great. So approximately 62% of the many digital devices, 31,579 searches the agency conducted between 2017 and 2020, found no evidence of any border law violations. This significant invasion of the privacy of many innocent travelers is a strong sign that the law is unreasonable. So they only actually found stuff 38% of the time. So substantially more often than not, they're finding nothing, but they've still gone through all your business, right? All right, so skipping ahead a little bit here, they note that one of the big problems is those 62% of people have no real recourse to fight this. This is one of the big reasons why evidence gets excluded in things, is that the only people who have any sort of interest in fighting these, or any ability in many cases to fight these searches, are the people where bad things are found. So they say the oversight problem is even worse for searches that do not lead to charges. The Customs Act statutory review mechanisms are inapplicable to digital device searches that do not lead to either seizures of goods or to an agency determination that travelers are importing prohibited goods. In other words, to searches of travelers who are innocent of any wrongdoing. This is because basically the review processes, let's say I bring, I'm bringing this Carolina Reaper powder across the border. And they say, we're seizing this because we think this is prohibited. Maybe they think it's nose candy, and that would be a very bad idea, but that's what they've decided. So there are provisions under the Customs Act that allow me to say, no, that's actually a legal product. I can bring it in. I'm allowed. I'm not violating any rules. But you can't bring that application if they're not seizing things. You can't say, hey, you searched my stuff and you said everything was good, so I'm mad. There's just no review process there. They note the other review mechanisms do not lead to meaningful remedies. Complaints under the Privacy Act merely authorize the Privacy Commissioner to make recommendations that the agency is free to disregard. Canadian privacy law is, by and large, awful. And the agency's online complaints mechanism is an internal accountability tool with no legal consequences, i.e., it's to possibly fire somebody if they've behaved badly, but it doesn't actually, you can't change the law with it. The law thus creates the very problem of difficult to review discretionary searches that the case of Goodwin warns about. All right, so skipping ahead a little bit further here, they note the law needs a reasonable suspicion threshold. For all the same reasons, the Charter requires a reasonable suspicion threshold to protect the strong privacy interests of travelers in their digital devices, as enunciated in Category 2 of Simmons, i.e., reasonable suspicion. I agree with the trial judge that this threshold is the constitutional minimum. So carrying on here, we're skipping over a whole bunch of stuff here because otherwise we're going to be at this for hours. Remedy. So this is the solution, right? Having found that there's a breach, here's what we do to fix it. So the law's authorization of digital device searches is of no force or effect. So what does this mean? When the court finds that a law is unconstitutional, they have the power to strike it down. Now keep in mind, this is an Ontario Court of Appeal decision. It may not have effect outside of Ontario. However, I think other courts would be likely to follow this. But, if you're considering travel and this, and you're concerned, talk to a lawyer. Like, we're just going over a case here, but don't take this as specific legal advice or anything like that. So they determine that the law is going to be, declared of no force and effect, but to a limited degree. They say, first, I would read down the law by declaring that its authorization to search the electronic documents that digital devices contain is of no force and effect. So reading down involves declaring the law inoperative only to a precisely defined extent. So only the law's authorization to search the electronic documents that digital devices contain is unconstitutional, not its authorization to search other goods, which Mr. Pike and Mr. Scott have not challenged. So this means that they can still go through your bags, right? And they can still actually look at your digital device. Like this phone has a phone protector cover, right? They can examine the phone in a physical sense. They can You know, they could take this phone and they can eyeball it. They could pull off the cover here to see if I've hidden something underneath it. You know, there's not a lot of room there, but maybe enough to hide something. You know, those kinds of things. They can search through your stuff, but they're saying this does not authorize the same kind of blanket searching of electronic documents. So, all right, they say basically that's the limited extent that they're striking it down. They say, second, I would suspend the declaration of unconstitutionality and delay it from coming into effect by 6 months. That means that the law is still valid for the next 6 months, because this provision allowing for the suspension of a declaration of unconstitutionality allows for the court to basically say, government, I know we're creating a problem for you and you might want to fix it. We're giving you time to fix it. We're giving you time to pass new law to correct whatever hole we've just carved into your old law. So this is a pretty common thing here. They note, third, the suspended declaration is prospective, meaning that the law will only be inoperative on a forward-looking basis once the declaration takes effect, and not from the moment the law was enacted in 1985, i.e., we're not reopening a whole bunch of old cases. This is only for things going, you know, from now on. So fourth, I would exempt Mr. Pike and Mr. Scott from the suspended declaration so that the law is of no force or effect in the Crown's case against them. The Supreme Court has held that litigants who successfully challenge a law's constitutionality are generally entitled to an exemption because they have advanced the public interest in constitutional compliance, i.e., why would anybody challenge a law if they were not going to benefit from successfully striking it down, right? If the court says, congratulations, we've determined that it's unconstitutional, but it still applies to you, then nobody's ever going to challenge this. This provides a sort of incentive or a reason why you would challenge this, because ultimately we determined that challenging unconstitutional laws is in everybody's interest, right? It's in the public interest. So this general rule applies here because a suspension would not unduly jeopardize the interest that the law advances. This is so because, as I explain later in these reasons, it does not automatically lead to the exclusion of the evidence of the bad pictures that the agency found on their digital devices. In fact, the court admits that. So they say, rather, the test for exclusion of evidence under Section 24.2 of the Charter accounts for the state's interest in holding Mr. Pike and Mr. Scott accountable for the bad pictures crimes with which they were charged, as well as for border officers' good faith reliance on the law's constitutionality. Okay, skipping ahead a little bit more here, they note, the evidence against Mr. Pike and Mr. Scott is admissible. This is the thing I mentioned. They're like, they violated your rights. It really sucks for you, but the evidence still goes in. This is kind of special in Canadian law, and sometimes it can seem like a good thing, sometimes it can seem unfair. Let's talk about it. So they say Section 24.2 of the Charter provides that evidence obtained in a manner that breaches Charter rights shall be excluded if its admission would bring the administration of justice into disrepute. Courts evaluate whether to exclude evidence by balancing the three grant factors. 1, the seriousness of the Charter infringing state conduct. 2, the impact of the breach on the accused's Charter-protected interests. And 3, society's interest in trying the case on its merits. Now, I'm not going to go through that full analysis here because that full analysis is very long, and I think you can probably do it in your head here. Basically, a lot of it comes down to what they mentioned before, which is the border officers thought the law was fine. Many cases had said that it was fine. And so given that that was their belief, that this law was okay, and that they weren't like trying to violate the law, if you've got a border officer who knows that they're violating, you know, your rights and is doing so intentionally, then the court would be much stricter on that, right? The court would be very inclined to be like, no, that is unforgivable, full stop. But where the behavior is kind of inadvertent, they're like, we'll let it go, right? So Here, that's the case, but a really big factor is just the court is like, these offenses are horrible. And because these offenses are horrible, we're going to allow the evidence in. And so that's probably going to lead to a conviction for Mr. Pike. It confirms the conviction for Mr. Scott, and that's that. So ultimately, you can see that this is a case where the defense lawyers were representing people who were found with bad pictures. And people say, how can you represent those people? Well, at the end of the day, those defense lawyers have done a solid for everyone else who travels across the border, because if you are an innocent traveler, you deserve for them not to go through your business without having some sort of reason. The court here isn't requiring a lot of reason. It's actually a really light standard, but the court is saying it's got to be something more than just you're not being a jerk. Because that's really what the good faith standard is like, you can't be just creeping on an attractive woman. You can't be doing it because you're, some sort of bigot. You can't be doing it for some ulterior motive. That's such a low standard, right? It's just, you can't be an active villain. Okay, but like, I deserve not to have my rights violated by somebody, even if they're not actively engaging in villainy, but just because it's like, well, we just look at everybody's computer, right? And theoretically, you'll note that the court said, listen, there were no real restrictions built into the law. So theoretically, they could go and image every single person's computer crossing the border. That's messed up, right? Copy every file you've got and go through it in incredible detail. It's not cool. It's not okay. So I'm glad the court is making this step. Anyway, let me know what you think in the comments below. I know there's going to be lots of people who are like, I'm glad they got convicted. And yeah, as I said, I don't got sympathy for those guys, but I'm glad that the law is being, amended, or that they're carving a hole in it to allow for more privacy for the rest of us. Anyway, thank you guys for watching. As I mentioned, I will link the full case in the description below, so you can check it out. 118 pages. Yay! But we sort of covered the critical bits, I think, so yep. If you want to read the full thing, you're probably a lawyer or a law student or just really nerdy, and I'm there for all of those things, but just letting you know. I also want to thank my Patreon supporters. There's a link to the Patreon in the description below. At the $50 level, Purple Dragonair, Cielo, CCFR, PJs Forever, Canada's National Farm Association, Bottles Shock and Oz, and the Canadian Shooting Sports Association. And at the $20 level, Aaron Gruben, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.